strongly agree with the concluding remarks of Deputy Pringle. While obviously all deputies will welcome this bill to a point, we'd have to say that it's incredibly long overdue. And while it's okay, I mean, the reality is it's pretty underwhelming when you think about it in terms of the challenges that are out there, in terms of what he could have been doing. I mean, in reality, you've kind of brought us back to where we were in 2007. Back 8 years, and it's packaged as some sort of progress. I really don't think that's good enough for a party that claims to have the legacy of James Connolly. Now, obviously, the background to this is the Ryanair against the Labour Court and Impact case, which, if you like, encapsulated Ireland's voluntarist tradition of collective bargaining, and which did have, subsequent to that, and in the intervening years, including the 4.5 years of year government where you've deliberated on this, a chilling effect across industry, where the use of the Labour Court was much less in terms of determining trade disputes. And you came to office well over 4 years ago, and you said that the programme for government included in it a promise to reform the current law on employees' right to engage in collective bargaining so as to ensure compliance by the state with recent judgments of the European Court of Human Rights. And 4 years later, we're finally getting to see this bill. Now, that's good, but it's not exactly great for the Dunnes Stores workers who have been victim of some of the practices that your bill is now belatedly attempting to address, where people are being victimised for their participation in trade disputes. We know that 20 Dunnes workers were sacked. We know that a brutal regime of intimidation has daily taken place against those who've remained because of their engagement in industrial action. We know the long-running and bitter Greyhound dispute which took place last year. Very good now that this bill includes a provision that, where people are covered by an REA, an employer won't be able to lock them out. But these workers in this city were locked out for 14 weeks last year. And the idea that an REA in and of itself is just a panacea, as the other deputies have said, is clearly not the case. So while we obviously welcome that some of these measures have now finally come through, they are a bit late. And I find it a bit insulting when you're able to ram through the sale of Aer Lingus in a day and a half without any notice that we have to drag our heels around for 4.5 years on this. And I would point out that as part of that debate, you placed great stock on the REAs and how they were some sort of a gold card, get out of jail free guarantee against everything. Well, do you know what? They aren't, because all of that they cover are terms and conditions. They don't defend you against outsourcing or job losses or anything like that. And in actual fact, fighting and democratic trade unions are the only way to get out on that. But let's look at Ryanair, which was the company behind this. A company still now where unions are not recognised, where staff are on airport standby, where they have to hang around the airport for 8 hours in case somebody doesn't show up. While they're there, they have to sell rail and bus tickets. 30 euros they get for that job while they're hanging around. It equates to about a payment of $3.75 an hour. They can work 12 hours without a break. Rest periods aren't respected. Sick pay isn't respected. Wages are based on flight time, even those are the mandatory hanging around time as well. Targets are all about the sales, are linked to your pay. So if you're on a flight to Manchester, you got to start selling even as the aircraft is climbing, which is completely against safety regulations. So there's no doubt that the failure of this government to act quicker on this vital piece of legislation has had a chilling effect throughout the years of year office. And over that period, there's been a 2% cut in wages across the economy. So, you could even say, was that deliberate? Really what your government will be responsible for is that you were the ones who supposedly reformed the JLC system. In other words, that you absolutely gutted it, and the protection for the most vulnerable workers in our society in retail, accommodation and catering and so on hasn't been protected. And while we talk about collective bargaining, is that really what this is? Because it's welcome. But the most glaringly obvious failure of this is the absence of a requirement on employers to recognise trade unions and engage with them. End of. That's the biggest fault in this. It maintains Ireland's voluntary system of industrial relations, which is something which IBEC said is absolutely necessary. So this is basically dancing to the tune of IBEC as far as I'm concerned. I do think that, the definition of collective bargaining in the bill is weak. It doesn't offer enough protection to workers. It talks about voluntary engagements between employers and trade unions or accepted bodies. What constitutes engagement? We don't know. I'm quite sure lawyers in the Labour Court will exploit that vagueness to the detriment of workers. Neither the Labour Court recommendation nor international collective bargaining legislation contains the phrase voluntary engagement. So what does it mean? So I think there are a huge amount of issues on this which needs to be looked at. I think points made by other deputies about the pensioners is absolutely critical. These are people who are denied an avenue to the industrial relations machinery at the moment because they're not deemed to constitute employees, even though issues that are occurring which affect their material well-being now, which related to their historic employment, are valid, and they don't have a say. So we need to look at that. The bill does something to improve the lot of workers in the country, but it's not enough, and it does essentially bring us back to 07, so it needs to be dramatically changed.